Hi, I'm Remy. I work with technical support here at Therapy Appointment.
And I am Clinton Campbell. I am a consultant for Therapy Appointment with Corktree LLC. We're finding that a lot of providers don't already understand or don't understand the responsibilities they already have to provide access to records. In particular, within the mental health field, which I've worked as well, we often have a mentality of being hesitant to release things like progress notes directly to clients. And so we might hold some of that back. The most important thing there is that we have very few exceptions that we can hold to. Like if we actually know that we're going to see harm to a client or something like that, if they read their notes, or that's likely to cause physical harm or real harm in some way, then yes, we can hold those notes back. But outside of those situations, ultimately the client is in charge of their care and they're in charge of their health information. And so we have to fulfill those in a prompt manner. When we're talking about what it means to fulfill things in a prompt manner, that is set, at least within HIPAA, as a 30-day maximum. But when we start to look at the nuances of the Curious Act, they say, well, if you always respond on day 29, you still may be considered information blocking if you didn't need that long to do it. If it was reasonable for you to just click a button and release a record to somebody, you're expected to do it promptly. You have up to 30 days, but you're supposed to do that as quickly as possible. And anybody watching this should also be aware that that like 30-day time frame may change here in the next year or two, depending on what happens with some proposed changes to HIPAA and the privacy rules there. That 30-day window may slide down to a 15-day window to release notes or other things to clients when they ask.
So essentially, they should not delay in responding to these and serving these requests.